So, Malas, the point that I'm making here is very simple, that the government of the day accepted the fact that our relationships with the Jammu and Kashmir government are on a separate footing. The provisions of the Constitution, unless made applicable through a presidential order and agreed to by the government, shall not apply. The residuary power will vest in the state. It is the state which must pass laws. The government of India can't, under the issue of repugnancy doesn't apply. So, well, this status is accepted. That's how 370 came into being. And it continued. Yes, that will come to later. Then the distribution of revenues, comes, and that we are not really concerned with at the moment. Your Lordship, just a historical fact, at that point in time, Sheikh Abdullah was in prison. And he had been always against the ruler, because he wanted the will of the people of Jammu and Kashmir, and not a despotic ruler. So he was against the Sadr-e Riyasat, so to say. But when he realized that, look, unless I get him on my side, I'm not going to be able to defend. So he released him and said, you form the interim government. Just a historical fact. That's how it happened. Yeah, no, I know that, but I don't want to bring politics into it. The moment I take somebody's name, they'll be the other side. No. Nehru had nothing to do with it. So I don't want to enter into politics here. No politics. I don't want fireworks in a very solemn occasion like this. So the assumption is that if the president passes a notification for the application of any law to the state of Jammu and Kashmir, he has to seek concurrence. He cannot do it without concurrence. Consultation. Yeah. So it was a collaborative relationship in a sense. There was a constant dialogue going on. This is what we wish to do, and consult the state agrees, which is why most of the laws were made applicable. There was hardly any law that was left. So in a sense, they were incorporated separately in the Constitution of India in its application to the state of Jammu and Kashmir orders.
What happened to currency, for instance?
Currency, was the Sadr-e Riyasat, as your Lordship knows.
Currency.
No, currency was Indian currency.
No, because, if you see currency in the Constitution is governed by entry 36 of List 1.
Yes.
But there is no reference to entry 36 of List 1 in the adaptation order.
Well, it will come later. There were adaptation orders, subsequent adaptation orders. I'll come to that. I'll show that, your Lordship. Because several, this comes in 1954, we have another adaptation order. There are several, give me on the list of several adaptations. We got a list by your Lordship.
So were the subjects broadened by the subsequent adaptation order?
Of course. They were broadened, Every state they were broadened. We have an order of 52, we have an order of 54, we have an order of 71, an order of 74. Because the powers were extended, and the state, after consultation it was done. The state was ad idem with the union, the state itself in its constitution says that we are integrated into India. There was no question. The Constitution of Jammu and Kashmir itself says that we are an integral part of India. So where's the question? The only thing is that there's a unique structural system in place, a constitutional structure which was in place, which suddenly, on the 6th of August, was done away with. And with the greatest respect, though I don't want to use that expression, suddenly, in Parliament, it was said that we are doing this at 11 o'clock. Nobody knew about it. There was no consultation of any sort. So it was, Malas, as I said, the governor of the state and parliament, and of course the powers that be, they decided to do this one fine morning and tossed it out. So, Malas, page 41. The Government of India published its white paper on Indian states clarifying the nature of Article 370. The effect of this provision, this is important. We're talking about 1950 itself. The effect of this provision is that the state of Jammu and Kashmir continues to be a part of India. Nobody disputes it. Nobody ever disputed it. It is a unit of the Indian Union. And the Union Parliament will have jurisdiction to make laws for the state on matters specified either in the instrument of accession or by later additions with the concurrence of the government of the state. My lords asked me that question. Steps will be taken for the purpose of convening a constituent assembly. Lordship knows, Malas, this is very important. At that time, when, Malas, we became a republic, 370 was there. And 370 mentions the Constituent Assembly. But the Constituent Assembly had not yet been convened in the state of Jammu and Kashmir. That was convened in 1951. December. Point is that there was this understanding between the Government of India and the state that we will have a Constituent Assembly which will determine the future course of action. Determine whether or not, Malas, in fact, 370 should be abrogated at all or not. That decision was with the Constituent Assembly. Which is why it is called a temporary provision. Not for any other reason. It's in that chapter of the Constitution. So this whole argument that this temporary provision was 370 was temporary, no. It was temporary because between 1951...
Mr. Sibal, what is the date of this white paper?
50, 90, I'll give you...
No, you're not given the date.
I'm sorry, it's at page 121, just see the date. We'll just give it to you in a minute. I'll give it to your lordship, just. So on the 1st of May 1951 now, Yuvraj Karan Singh issued a proclamation directing the establishment of an elected constituent assembly. March 1950, I'll give the exact date.
Okay.
It is March 1950s. Huh? Can't be.
It cannot be 5th July 48.
It can't be. We'll give the date, Malas. I thought it was March.
Article 370 wouldn't have been then.
But in any case, Malas, the idea is that it's prior to 1951. That's the whole point. Whatever the date is, Malas, it's prior to 1951. In other words, the Constitution envisaged a constituent assembly which was to decide as to what would be the fate of Jammu and Kashmir. 15th March 1950 is what I'm told, Malas. 370 for a minute, Malas, then give your lordship some.
No, just continue. Where you want. Whichever way you want.
No, Malas, let's read 370 because the context will be clear. That's how it was understood at that point in time. We're talking about January 26, 1950. Yeah. Well, it's my lords have the Constitution.
Yes.
It says, Malas, notwithstanding anything in this Constitution, the provisions of Article 238 shall not apply in relation to the state of Jammu and Kashmir. Now, 238, Malas, Part A, Part B, Part C, Part D states. That's what 238 was, Malas. So it couldn't apply. It's neither, the Jammu and Kashmir didn't fall into that category. Sui generis. The power of Parliament to make laws for the said state shall be limited to those matters in the union list and the concurrent list, which in consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession, governing the accession of the state to the Dominion of India, as the matters with respect to which the Dominion legislature may make laws for that state. And such other matters in the set lists as with the concurrence of the government of the state, the President may by order specify.